I have presided over thousands of cases in my courtroom. I've listened to excuses polished by expensive attorneys, tears that arrived too late, and apologies that sounded more like carefully rehearsed performances than genuine remorse. After decades on the bench, you develop instincts that no law school can teach. You learn to recognize fear before a witness speaks, guilt before evidence appears, and arrogance before a defendant even takes a seat. But there was one case, a seemingly ordinary civil dispute, that still returns to me on quiet nights. Believe me, when that woman walked through my courtroom doors, dressed as though she were attending a gala instead of a legal proceeding, I knew this day would not end the way she expected. Her name was Victoria Langford. If you had seen her outside the courthouse, you probably would have assumed success had followed her every step. Designer suit, diamond bracelet that caught every beam of light, confidence so overwhelming it almost felt theatrical. She didn't look at the people waiting in the hallway. She looked through them as though they were scenery placed there for her convenience. That, in itself, isn't a crime. Wealth isn't illegal. Confidence isn't illegal. But I've learned that when someone believes money has erased the rules everyone else lives by, the courtroom becomes the first place reality begins collecting its debt. Across the aisle sat Emily Carter, no expensive jewelry, no entourage, no celebrity attorney, just a worn navy blue blazer, trembling hands folded together, and a folder packed so tightly with documents that the corners had begun to curl. She avoided looking toward Victoria entirely. Some people mistake that kind of silence for weakness. I don't. Silence often belongs to people who've spent too long trying to be heard. The courtroom filled quickly that morning. A few local reporters wandered in after hearing rumors that one of the city's most recognizable businesswomen was appearing before me. Spectators whispered among themselves. They expected entertainment. They assumed this would be another wealthy defendant writing a check before lunch and walking away with a smile. I wasn't so sure. Before I called the case, I watched Victoria speaking with her attorney. She laughed, actually laughed. Not the nervous laugh people use to calm themselves, but the kind that announces absolute certainty. She wasn't worried about losing. She wasn't even preparing for the possibility. She carried herself like someone attending a business meeting where the outcome had already been negotiated. That bothered me. Years on the bench teach you that innocent confidence and manufactured superiority are two completely different things. One comes from truth. The other comes from believing accountability can be purchased. When I called the case to order, Victoria barely acknowledged me. That caught my attention immediately. Respect for the court isn't about flattering a judge. It's about respecting the law itself. The moment someone behaves as though the courtroom is beneath them, I begin paying closer attention than usual. Emily stood when instructed. Her voice shook as she identified herself. Victoria answered without even looking in Emily's direction. I assume we can make this quick, Your Honor. I remember the silence that followed those words, not because they were loud, because of what they revealed. People often expose themselves before testimony ever begins. Most just don't realize they're doing it. I asked both parties whether they understood the proceedings. Emily answered respectfully. Victoria sighed. Yes, Your Honor. I have another meeting this afternoon. She wasn't trying to insult me. She genuinely believed her schedule mattered more than the courtrooms. I've seen that mindset before. It rarely survives very long. The lawsuit appeared straightforward on paper. Emily claimed Victoria had intentionally breached a signed agreement involving a charitable fundraising partnership, causing devastating financial losses to Emily's small nonprofit organization. Victoria denied wrongdoing entirely, insisting Emily was simply looking for money after her organization failed. Simple enough, or so it appeared, but something wasn't adding up. Emily wasn't acting like someone chasing a payday. She looked exhausted, not angry, not greedy, exhausted. There's a difference. When I asked Emily why she had chosen to represent herself despite facing one of the city's most prominent legal teams, she hesitated before answering. I couldn't afford anyone else. Victoria smiled, not broadly, just enough for me to notice. That tiny smile stayed with me, because it wasn't confidence, it was satisfaction, as though Emily's lack of resources somehow confirmed everything Victoria already believed. I've watched countless juries over the years, and although this wasn't a jury trial, the gallery often becomes its own silent jury. I glanced toward the spectators. Several had noticed the same smile. I could almost feel the room shifting. Public opinion doesn't decide cases, and I never allow it to influence my rulings. But human behavior tells its own story long before documents are admitted into evidence. Then I asked Emily a question I ask only when my instincts tell me there's more beneath the surface. "Miss Carter," I said, "why do I get the feeling this lawsuit isn't really about money?" Emily looked down at the folder in her hands. For several long seconds she couldn't. When she finally raised her eyes toward me, they weren't filled with anger. They were filled with disappointment. She swallowed hard. She didn't just destroy my organization. The courtroom became so quiet that I could hear someone in the back row set down a pen. Emily continued. She destroyed people who trusted her. I turned toward Victoria. For the first time all morning, her smile disappeared, and at that exact moment, before a single exhibit had been admitted into evidence, I realized this case was hiding something neither side had mentioned in their filings, something much larger, something Victoria desperately hoped would never reach the courtroom. And believe me, I was determined to find out exactly what it was. The moment Emily Carter finished those words, I noticed something that most people in the courtroom completely missed. Victoria Langford reached for her glass of water. Now, that may sound insignificant to you. People drink water in courtrooms every day. But after years on the bench, I've learned that timing often tells a greater story than words ever could. She hadn't touched that glass once during the first several minutes of the hearing. Yet the instant Emily suggested innocent people had been harmed, Victoria's hand moved almost instinctively. Fear rarely announces itself. It leaks through ordinary moments. I leaned forward slightly. "Miss Carter," I said calmly, "this court isn't interested in speeches. Tell me exactly what happened." Emily nodded. She carefully opened the worn folder resting in front of her. Every document had colored tabs. Every receipt had handwritten notes. It wasn't the work of an attorney. It was the work of someone who had spent months trying to make sure the truth couldn't be ignored. "I founded the Bright Horizons Learning Center 6 years ago, Your Honor." Her voice remained soft, but every sentence carried the weight of someone who had repeated this story countless times. "We provided free tutoring, meals, and after-school programs for children whose families couldn't afford private education." She paused. "We weren't a large organization." Then she smiled sadly. "But we changed lives. I've heard hundreds of people praise their own businesses or charities over the years. Usually those descriptions sound rehearsed. Emily's didn't. She wasn't trying to convince me she was extraordinary. She simply wanted me to understand what had been lost." Victoria rolled her eyes. It was subtle, barely noticeable, but I saw it. "I assume there's a legal issue somewhere in this history lesson," Victoria muttered. I looked directly at her. "Mrs. Langford, you'll have every opportunity to speak. Until then, I expect you to remain silent." Her attorney immediately placed a hand on her arm. She leaned back without another word, but the expression on her face hadn't changed. She still believed this was beneath her. That confidence intrigued me because it usually comes from one of two places. Either someone knows they're innocent, or they believe they're untouchable. Experience has taught me never to confuse the two. Emily continued. 3 years ago, Mrs. Langford contacted us. According to Emily, Victoria's company had announced a highly publicized charitable initiative designed to improve educational opportunities across the city. The media loved it. Television cameras followed Victoria into schools. Newspapers described her as one of the city's most generous philanthropists. Magazine covers praised her leadership. Emily admitted she admired Victoria. So when her office offered us a partnership, Emily looked down. I thought our biggest dream had finally come true. That sentence lingered in the courtroom. Dream, not opportunity, not contract, dream. People who build charities rarely measure success by profit. They measure it by hope. And hope can be exploited just as easily as money. Emily explained Victoria's foundation promised substantial funding if Bright Horizons agreed to become the public face of several educational campaigns. There was a written agreement. There were scheduled events. There were promotional videos. Emily showed photographs of children smiling beside donated books and renovated classrooms. For a brief moment, even I found myself believing this partnership had been something genuinely positive. Then everything changed. About 8 months into the agreement, Emily said quietly, the payments stopped. Victoria's attorney stood. "Objection, Your Honor. The payments were contingent upon measurable performance metrics. I'll decide what they were contingent upon after reviewing the evidence," I replied. The attorney nodded and sat down. Emily reached into her folder again. This time she produced bank statements, invoices, e-poems, letters requesting clarification. Every unanswered message was neatly organized. I noticed something unusual. She hadn't highlighted emotional language. She'd highlighted dates. That matters. Facts survive longer than accusations. As funding disappeared, Emily explained, our teachers volunteered without pay. Her hands trembled. Our food suppliers waited months to be reimbursed. Another document. Our landlord delayed rent because he believed the funding would arrive. Another document. Parents began asking why programs were being canceled. She stopped speaking, not because she had run out of evidence, because she was trying not to cry. I've seen genuine grief enough times to recognize it instantly. It doesn't seek sympathy, it struggles to remain composed. Across the room, Victoria remained perfectly still, almost too still. People often believe emotional control signals honesty. Not necessarily. Sometimes it's simply preparation. I turned toward Victoria. Mrs. Langford? Yes, Your Honor. Did your organization suspend funding? Yes. And why? She answered without hesitation. Because Bright Horizons failed to satisfy contractual obligations. Simple, direct, confident, exactly the kind of answer expensive legal preparation produces. Then I asked a question her attorney clearly hadn't expected. What specific obligation? For the first time that morning, Victoria hesitated, only for a second, but in court, 1 second can speak volumes. Her attorney quickly responded instead. The agreement contained multiple discretionary funding provisions. I asked your client. Silence. Finally, Victoria answered, our auditors found irregularities. Emily looked stunned. What irregularities? I asked. Victoria glanced toward her attorney again. The investigation was ongoing. Ongoing, interesting word, not completed, not confirmed. Ongoing, that distinction immediately caught my attention. Years on the bench have taught me something simple. When someone relies on vague language instead of specific facts, they're often buying time, time to remember, time to calculate, time to avoid saying something they can't take back. I asked the obvious question. Did any government agency conclude Bright Horizons committed fraud? No. Did police open a criminal investigation? No. Were charges ever filed? No. So whose investigation some are we discussing? Another pause. This one lasted longer. The courtroom seemed to shrink around us. Even the spectators had stopped whispering. Then Victoria finally answered. Our internal compliance department. I nodded slowly. Tinnell, not independent Tinnell. That single word completely changed how I viewed the dispute because now I wasn't simply looking at a broken contract. I was looking at the possibility that a powerful organization had acted as investigator, prosecutor, and judge without outside oversight. And something about that bothered me more than I could explain. Then Emily quietly reached into her folder one last time. I didn't want to show this unless I had to, Your Honor. She held up a sealed envelope. I was hoping the truth wouldn't require it. The courtroom fell silent again. I looked at the envelope, then back at Emily. What is it? Her answer changed the atmosphere instantly. It's the document Mrs. Langford's company tried very hard to make sure no judge would ever see. I looked toward Victoria. The confidence she'd worn all morning was gone. Not completely, but enough. And for the first time since she entered my courtroom, I saw genuine concern in her eyes. That's when I realized we were no longer dealing with a simple breach of contract case. We were standing at the edge of something far more disturbing. I have often said that the most dangerous moment in any courtroom is not when someone raises their voice. It is when the room becomes completely silent. That sealed envelope created exactly that kind of silence. Every person in the gallery seemed to stop breathing at once. Even the bailiff, who had seen thousands of hearings, shifted his weight ever so slightly as Emily Carter stepped toward the clerk's desk. I held out my hand. Bring it here. The clerk walked the envelope to my bench, carefully placing it in front of me. Before I even opened it, I noticed something unusual. It wasn't addressed to Emily's. It wasn't addressed to this court. It bore the logo of Langford Community Foundation printed neatly in the upper left corner, and across the front in bold red letters were 2 words. Confidential. You've seen confidential documents before. Most of them deserve that label, some of them don't. I looked toward Victoria Langford. Mrs. Langford, are you familiar with this document? Her attorney answered before she could. Your Honor, before the court reviews anything, we'd like to object based on privilege and confidentiality. I folded my hands. Counselor, confidentiality doesn't automatically shield relevant evidence. If this document bears directly on the claims before this court, I'll determine its admissibility." His expression tightened. He knew I was right. I carefully opened the envelope. Inside were several printed emails, a memorandum, and what appeared to be an internal financial report. I didn't react immediately. That's one of the first lessons every judge learns. Never reveal your thoughts before you've examined the facts. But as I read the first page, something felt wrong, very wrong. The memorandum wasn't discussing Emily Carter's nonprofit as though it were a charitable partner. It discussed Bright Horizons as though it were a marketing asset. There were phrases that immediately caught my attention. Maximize media exposure, delay second-round disbursements, evaluate public relations value. None of those phrases were illegal by themselves, but they painted a picture that differed dramatically from the public image Victoria's organization had presented. I looked back at Emily. "Where did you obtain these?" She hesitated. "I received them anonymously." The attorney was on his feet before she'd finished speaking. "Objection. Anonymous documents with no verified source are unreliable." He wasn't wrong. Anonymous evidence requires careful scrutiny, but something else concerned me more. I turned toward Victoria. "Did your foundation create documents resembling these?" She didn't answer. Instead, she whispered something to her attorney. Noticed it immediately. People who know the truth often answer quickly. People calculating consequences usually consult first. Finally, her attorney spoke. "We cannot verify isolated pages removed from their original context." That wasn't a denial, and I noticed it. Believe me, after years on the bench, you begin hearing the answers people avoid giving. I continued reviewing the material. One email discussed postponing payments because, according to the writer, the public campaign has already achieved sufficient exposure. Another suggested redirecting remaining charitable funds toward higher-profile partnerships. Higher profile, those words echoed in my mind. Emily sat perfectly still. She wasn't smiling. She wasn't celebrating. She simply watched me, almost afraid of what I might conclude. Then I asked a question neither side expected. "Mrs. Langford." She looked up. "How many nonprofit organizations participated in your educational initiative?" She answered confidently. "Approximately 20. And how many experienced delayed funding?" Another pause. "I don't know." "You don't know." "Our accounting department handled those matters." I nodded slowly. "Convenient, very convenient." Over the years, I've watched executives distance themselves from decisions by hiding behind departments. Accounting decided, compliance decided, legal decided, marketing decided. Eventually, nobody seems responsible for anything. But organizations don't make decisions. People do. I turned back toward Emily. "Did you attempt to contact Mrs. Langford personally?" Emily reached for another folder. "I emailed her 12 times. She handed copies to the clerk. No response." I wrote certified letters, receipts. They were signed for delivery confirmations. I even attended one of her public charity events. She looked down. I wasn't allowed inside. The courtroom remained absolutely still. Then Emily quietly added something that struck me harder than I expected. "I didn't go there to embarrass her." She swallowed. "I went there because our teachers hadn't been paid in 3 months." No one moved. No one spoke. Those are the moments that stay with a judge long after the courthouse lights are turned off, not dramatic speeches. Tilled truths, I looked toward Victoria again. Her expression hadn't softened. If anything, it had become colder. "Mrs. Langford," I asked, "did anyone from your organization explain to Bright Horizons why funding stopped?" "Our compliance findings justified the decision." "The question wasn't whether you believed it was justified." She remained silent. "The question was whether anyone explained it." Finally, no. Emily closed her eyes. Only for a second, but I noticed because disappointment often hurts more than anger. Then something happened that changed the direction of the hearing completely. The court clerk approached my bench with a note. I read it once. Then again, it informed me that another individual had just arrived at the courthouse requesting permission to testify. He wasn't listed as a witness. Neither side had disclosed him. According to the note, he claimed to be a former senior employee of the Langford Community Foundation. More importantly, he insisted he possessed firsthand knowledge of why the funding had actually been terminated. I looked toward both attorneys. Neither appeared pleased. Victoria's face changed instantly. Until that moment, she'd remained composed despite Emily's documents. Now, the color slowly drained from her face. That reaction interested me more than any objection her attorney had raised all morning. Fear doesn't always come from damaging evidence. Sometimes it comes from the arrival of someone who knows where the evidence is buried. I asked the bailiff one simple question. "Is he still outside?" "Yes, Your Honor." I looked around the courtroom. The spectators had begun to bring again. Reporters reached for their phones. Even the attorneys looked unsettled. Years on the bench have taught me never to chase drama, but they have also taught me never to ignore a witness whose arrival causes one party to panic before they've spoken a single word. I leaned back in my chair. If this man was telling the truth, everything we'd heard so far might only be the beginning, and I had a growing suspicion that Victoria Langford's greatest problem wasn't the documents already sitting on my bench, it was the person waiting just outside my courtroom door. I have always believed that the most powerful evidence in any courtroom is not a document or a photograph, it's a witness who has nothing left to gain by speaking. The bailiff opened the courtroom doors, and a man in his early 50s walked inside. He wasn't dressed like an executive. His navy suit had clearly seen better days, and the leather briefcase he carried looked as though it had traveled through years of board meetings and airport terminals. He paused for a moment, scanned the room, and then looked directly at Victoria Langford. She refused to meet his eyes. That told me more than any introduction could. The clerk administered the oath. "My name is Daniel Mercer," he said. "I served as Chief Financial Officer of the Langford Community Foundation for nearly 11 years. A ripple spread through the gallery. I noticed reporters sitting a little straighter. Pens moved across notebooks. Camera operators quietly adjusted the petitions outside the courtroom windows. Victoria's attorney stood immediately. "Your Honor, this witness was never disclosed." "I am aware of that," I replied. "The court will determine what testimony is appropriate." Then I turned to Daniel. "Mr. Mercer, why have you come here today?" He took a slow breath. "Because I've spent 2 years regretting my silence." That sentence lingered in the room. People often imagine whistleblowers as fearless heroes. They rarely are. Most are frightened people carrying the weight of decisions they wish they had challenged sooner. Daniel wasn't dramatic. He looked tired, deeply tired. "I resigned 18 months ago," he continued, "not because I wanted another job, but because I couldn't keep signing documents I knew weren't ethically defensible." Victoria's attorney objected again. "Speculation sustained," I said. "Mr. Mercer, limit yourself to facts within your personal knowledge." "Yes, Your Honor." He opened his briefcase and carefully removed several binders. Unlike Emily's folder, these were professionally organized. Each tab carried department names, dates, and financial references. He placed them on the evidence table. "I supervised every charitable disbursement over $100,000. I leaned forward. "So you would know why Bright Horizons lost its funding?" "Yes." "And why was it terminated?" Daniel looked toward Victoria for the first time, then back at me. "Because it became inconvenient." The courtroom erupted into whispers. I raised my hand. "Order." Silence returned almost instantly. "Inconvenient in what sense?" I asked. Daniel answered carefully. "Bright Horizons was producing excellent educational outcomes." Emily looked confused. "So why terminate them?" I asked. He swallowed. "Because educational outcomes weren't the primary objective." Those words landed heavily. I glanced toward Victoria. She remained motionless, almost unnaturally still. Years on the bench have taught me that when someone suddenly stops reacting altogether, they are often calculating every possible consequence. Daniel continued. "The foundation measured something else." "What?" He opened one binder, media visibility. He pointed to a spreadsheet. Each nonprofit partner received internal ratings. He explained that organizations appearing frequently on television, generating favorable headlines, or attracting influential donors were classified as high-value partners. Others, no matter how effective their programs, were categorized differently. Emily quietly covered her mouth. I looked at Daniel. "And Bright Horizons?" He hesitated. "They received outstanding educational evaluations, but they attracted very little media attention." Another silence, one that felt heavier than before. Daniel continued. "The recommendation wasn't to improve their funding." He turned another page. It was to redirect resources toward organizations offering greater public relations benefits. Victoria's attorney quickly approached the witness. "Mr. Mercer, isn't it true these documents represent internal discussions rather than final decisions?" "Some do, so they don't prove my client acted improperly." Daniel looked directly at him. No. The attorney smiled slightly, then Daniel finished his sentence. They prove your client approved the final decisions herself. That smile disappeared. I watched Victoria carefully. For the first time all day, she shifted in her chair barely, but enough. I've watched defendants remain composed through overwhelming evidence, only to reveal anxiety at one unexpected statement. This felt like one of those moments. The attorney requested permission to examine the binders. I granted it. Several tense minutes passed while both legal teams reviewed the material. I used that time to observe. Emily never took her eyes off the evidence. Victoria never took her eyes off Daniel, not once. There was history between them, professional, personal, or perhaps both. Then I noticed something unusual. Daniel had not yet looked angry, disappointed, ashamed, regretful, but not angry. People driven by revenge usually sound different. They exaggerate, they editorialize. Daniel did neither. He answered only what I asked, nothing more, nothing less. That made his testimony increasingly persuasive. I asked another question. Mr. Mercer, why didn't you report these concerns when you were employed? His answer came almost immediately. I was afraid of losing your position. That was part of it. What was the other part? He looked toward the gallery before answering. I believed no one would challenge someone as powerful as Mrs. Langford. Another wave of silence. Power, that word had hovered over this case from the beginning, not wealth. Power, there is a difference. Money buys opportunities. Power convinces people they no longer need permission. I have seen it corrupt elected officials, executives, professionals, and ordinary citizens alike. No one is immune. Daniel reached into the briefcase one final time. I haven't shown anyone this. He held up a small digital storage drive. Victoria stood so suddenly that her chair scraped loudly across the courtroom floor. No, it was the first genuine emotional reaction she'd shown all day. Her attorney immediately tried to calm her, but the damage had already been done. Every person in that courtroom saw it, including me. I looked at the flash drive. What is on it? Daniel answered quietly. Recordings. The room became perfectly still. Recorded board meetings. Victoria closed her eyes only for a brief second, but I saw it. I made them because I feared documents might disappear someday. I stared at the drive resting in Daniel's hand. Years on the bench have taught me never to assume recordings reveal what people expect. Sometimes they help, sometimes they mislead, but one thing was suddenly beyond dispute. Whatever existed on that drive, Victoria Langford was terrified of it becoming public, and deep in my instincts I felt we were only one step away from uncovering the truth that had been hiding beneath polished speeches, charitable press conferences, and carefully crafted public image. What none of us knew was that the first recording would reveal something so shocking that even I, after decades on the bench, would struggle to believe what I was hearing. There are moments in a judge's career that divide time into two parts. Everything that came before and everything that came after. The recording we were about to hear became one of those moments for me. I looked at the clerk. Has the authenticity of this recording been established? Daniel Mercer answered before anyone else could. Yes, Your Honor. The original files were preserved with their creation dates, and duplicate copies were provided to federal investigators after I resigned. These are exact copies. The words federal investigators immediately changed the atmosphere. Victoria's attorney rose to his feet. Your Honor, I object. Unless there is proof that any agency has verified these recordings, that statement is prejudicial. I'll disregard any implication beyond what can be supported, I replied calmly. For now, the court is concerned with whether this recording is relevant and authentic. Daniel nodded. I understand. The courtroom had become so quiet that I could hear the faint hum of the projector above us. I have always believed that silence has its own language. Sometimes it announces hope, sometimes fear. That day, it announced truth. The clerk connected the storage drive to the courtroom's evidence system. The large monitor flickered to life. There was no video, only audio. A date appeared on the screen. It was recorded nearly 14 months before Bright Horizons lost its funding. Begin playback, I instructed for a few seconds. Nothing, then voices. The sound quality wasn't perfect, but it was clear enough to distinguish every speaker. One unidentified board member said, Bright Horizons is receiving excellent evaluations. Independent reviewers say they're outperforming every other educational partner. Another voice agreed. So why are we discussing ending the partnership? Then I heard Victoria Langford. There was no mistaking her voice, confident, measured, completely in control. We're not in the business of rewarding invisible success. No one in the courtroom moved. The recording continued. Our donors invest in visibility. Another board member responded cautiously, but the children are benefiting. Victoria answered almost immediately. Children don't attract investors. I remember blinking, not because I doubted what I'd heard, because I wished I had. The courtroom remained frozen. Then came the sentence I will never forget. If a program doesn't improve our public image, it's an expense, not an investment. The words echoed through the speakers. No one whispered. No one coughed. Even the reporters had stopped writing. They were simply listening. Across the courtroom, Emily Carter lowered her head. Not in triumph, in heartbreak. You see, that's something people often misunderstand about cases like these. The injured party rarely celebrates when the truth finally appears, because by the time justice arrives, the damage has already been done. Victoria's attorney immediately stood. Your Honor, those statements have been taken completely out of context. Then provide the context. He hesitated. The discussion involved long-term strategic planning. I folded my hands. Counselor, I asked for context, not interpretation. He looked toward Victoria. She remained silent. That silence spoke louder than any legal argument. I instructed the clerk to continue the recording. The next several minutes revealed detailed discussions about charitable partnerships, projected media coverage, sponsorship value, and financial relocations. Nothing illegal on its face. Then the conversation changed. A board member asked a question that altered everything. What about the contractual obligations we've already signed? Victoria answered without hesitation. Our legal department can delay payment long enough that most small nonprofits won't survive litigation. I felt the air leave the courtroom. I've heard defendants admit mistakes. I've heard people confess fraud, theft, and deception. But hearing someone calmly discuss using financial power to exhaust smaller organizations, that struck me differently because it wasn't impulsive. It was calculated, premeditated, methodical. Emily quietly wiped away a tear. Daniel Mercer stared at the floor. Even Victoria's attorney looked visibly uncomfortable. Then came another voice on the recording. It belonged to Daniel. We're exposing the foundation to serious legal risk. Victoria laughed, not loudly, just enough to make the next sentence unforgettable. Legal risk only exists for people who can't afford lawyers. I have replayed that sentence in my mind more times than I care to admit, not because it was dramatic, because it revealed a philosophy, a belief, one that no amount of public charities could disguise. I paused the recording. The courtroom remained completely silent. I looked directly at Victoria. Mrs. Langford, she slowly met my eyes. Is that your voice? For several long seconds, she said nothing. Finally, yes, no denial, no explanation, just one word, yes. Years on the bench have taught me that admissions often arrive after people realize denial has become impossible, but I wasn't finished. Did you knowingly authorize the suspension of funding despite contractual commitments? Another pause. Her attorney whispered something urgently. Victoria ignored him. Then she answered, yes. The gallery gasped. I raised my hand for order, but inside, even I was stunned. Not by the admission itself, by how calmly it was delivered, almost as though she still believed honesty no longer mattered because the outcome couldn't touch her. Then she added one final sentence. I did what was best for my foundation. I leaned back. No, my voice was quieter than before. You did what was best for your image. She looked at me for the first time without confidence, without superiority, without certainty. Only then did I see something I hadn't seen all day. Regret, not regret for the decision, regret that the truth had finally escaped the boardroom and entered a courtroom where influence, wealth, and carefully managed public relations meant absolutely nothing. But there was still one question I needed answered, one question that would determine whether this case ended as a civil judgment or became something far more significant. And the answer was waiting inside a single financial ledger that had just been handed to my clerk. There is a misconception about judges that has always fascinated me. People assume our most difficult responsibility is deciding who wins and who loses. It isn't. The hardest part is recognizing that every ruling reaches far beyond the people standing before the bench. Every decision tells a community what the law values and what it refuses to tolerate. As the clerk placed the final financial ledger on my bench, I understood that this case had grown into something much larger than a dispute between Victoria Langford and Emily Carter. It had become a test of whether influence could outweigh accountability. I opened the ledger slowly. Years on the bench have taught me never to rush the final pieces of evidence. Sometimes the smallest entry reveals the biggest truth. Page after page detailed charitable allocations, marketing expenditures, executive travel, sponsorship events, and administrative costs. Then I reached a section highlighted with handwritten notes. A transfer had been authorized just 4 days after Bright Horizons funding was suspended. The amount was almost identical to the money Emily's organization had been expecting. But it hadn't gone to another educational program. It had been redirected to an extravagant fundraising gala hosted at a luxury hotel. The ledger described it as a strategic brand investment. I looked toward Daniel Mercer. "Did you authorize this transfer?" "No, Your Honor." "Who did?" he answered without hesitation. "Mrs. Langford." Victoria didn't object. She didn't even attempt to explain. She simply stared at the tabletop in front of her. I addressed her directly. "Mrs. Langford, while teachers at Bright Horizons were working without pay, while children lost tutoring services, while suppliers waited months to be reimbursed, you approved moving those funds to an event designed to improve your foundation's public image. Is that accurate?" Her voice was barely audible. "Yes. No excuses, no qualifications." Just another admission. The courtroom remained utterly still. I looked toward Emily. She wasn't crying anymore. She looked relieved. That surprised some people in the gallery, but not me. Relief often arrives when the truth is finally acknowledged. Justice cannot erase suffering, but it can end the loneliness that comes from not being believed. Victoria's attorney made one final attempt. "Your Honor, my client acknowledges mistakes in judgment, but this was a business decision made in good faith." I turned toward him. "A business decision?" "Yes," I nodded once. "Businesses are expected to honor contracts." He said nothing. I continued. "Businesses are expected to deal honestly." Silence. "They are not permitted to weaponize superior financial resources against organizations that lack the means to defend themselves." The attorney slowly sat down. "I have never believed that anger improves a judgment. The law deserves calm." So I spoke carefully. "This court is not punishing success." I looked directly at Victoria. "It is addressing conduct." I explained that wealth carries no exemption from contractual obligations. Charitable branding is not charity if promises become disposable the moment publicity declines. Power is not measured by how easily someone can dominate those with fewer resources. Power is measured by what someone chooses to do when no one is watching. And in this case, the recordings had shown exactly what happened when Mrs. Langford believed no courtroom would ever hear her words. I entered judgment in favor of Emily Carter. The damages reflected the financial losses proven through contracts, unpaid obligations, and documented operational harm. I also ordered reimbursement of court costs permitted under the law. The amount itself mattered, but the principle mattered more. As I finished reading the judgment, I noticed something unexpected. Victoria stood. Her attorney looked confused. "So did everyone else," she asked quietly. "May I say something?" Normally after judgment there is little left to discuss, but I allowed it. She turned not toward me, but toward Emily. For the first time that entire day, there was no trace of superiority in her posture. I spent years believing success meant never admitting weakness. She paused. I convinced myself every decision was justified because I could afford the consequences. Her voice faltered. "I never considered that other people couldn't." Emily listened without interrupting. Victoria continued. "I can't undo what happened." Another pause. "But I can stop pretending it wasn't my fault." No one applauded. This wasn't a movie. Real accountability rarely receives applause. It receives silence, the kind of silence that forces everyone present to reflect on their own choices. After the courtroom emptied, I remained on the bench for several minutes. That isn't unusual for me after difficult cases. I looked at the empty chairs where spectators had been sitting. The microphones had been turned off. The lawyers had left. The files were stacked neatly beside the clerk. Yet one thought refused to leave my mind. People often ask whether money changes people. In my experience, money usually reveals them. Character isn't tested when life is comfortable. Tested when someone has enough power to believe the rules no longer apply. Victoria Langford entered my courtroom convinced her wealth would protect her from accountability. She left having learned the one lesson every courtroom exists to teach. Justice does not measure bank accounts, it measures actions, and no matter how expensive the suit, how influential the name, or how carefully crafted the public image, no one is above the law. That case has stayed with me ever since. Not because it involved a wealthy defendant, not because of the headlines it generated, but because it reminded everyone in that courtroom, including me, that integrity is worth more than reputation, promises are worth more than publicity, and the law has only one purpose when the truth finally comes to light: to make sure that accountability cannot be purchased.